Question then is, where consent has been given under the directive, is this consent still valid under GDPR? So that will really depend on what consent you received initially. So under GDPR, consent needs to be specific, it needs to be informed, it needs to be free, and it needs to be unambiguous, okay? And the GDPR itself gives guidance around what those terms are, and there has been previously an Article 29 Working Party paper around consent as it relates to the current regime, but is equally applicable around the whole idea of consent now. So consent obviously being free means no imbalance of power between the parties as an example. So for example, for the most part in the employer-employee relationship, there is an imbalance of power there, so it would be difficult to rely on consent being free in that relationship. Consent needs to be specific. So what you're looking at there is the fact that if an organisation is processing personal data for different purposes, well then the data subject needs to be given consent in respect of each of those purposes separately. So that's really important. Consent needs to be informed. There's certain information that you need to give to a data subject to make sure that they know what it is you are doing with their personal data. And if you take a look at Articles 13 and also 14 of the GDPR, it will give you further guidance in relation to that. And then finally, the consent needs to be unambiguous. And really, in terms of unambiguous, we're looking for some form of positive action on behalf of the data subject, which indicates their consent to the processing of the personal data. I think it's important that if you are intending to rely on consent that has been previously given, that you are doing a gap analysis there to see, okay, well, what type of consent have we received previously, and does this stack up in terms of what's required for consent under the GDPR. Also, just to note that if you're processing special categories of personal data, or alternatively if there's transfers outside of the EEA, well then consent on that case needs to be explicit rather than unambiguous. So there's obviously a fine line there. I think for explicit you're looking really very much for, something is a level higher, I suppose, marginally higher anyway, than unambiguous. So I think it's important to remember as well that consent is not the only basis on which you can lawfully process personal data. You take a look at Article 9 of the GDPR, it's very clear there that there are other grounds that you can process personal data, such as for the legitimate interests of the organisation, once it doesn't infringe on the fundamental rights and freedoms of the person, or alternatively as well under a contract. So I think organisations should be looking at the various different ways that personal data can be processed. And consent is lots of organisations use that as their first port of call, but I would be suggesting that there are other bases on which you could be processing personal data that may in fact be a better option for you.